This is a part held appeal in the matter of One Tower UK Ltd and British Telecommunications PLC.
Mr. Lees.
Good morning, my lady. My lady, my lords, remember yesterday we finished ground 1 and the point of principle. Today we turn to grounds 2 and 3, which I'll overlap to a significant extent in terms of the material I have to take your ladyship and your lordships to. So I will, to some extent, deal with them together and then just at the end separate out effectively the differences between the remedy as much as anything else, which is, as I remind your ladyship and your lordships, our primary position is that this is a matter that, if the appeal is made out, ought to be remitted back to the Upper Tribunal for determination. But if you were with me on the procedural point but against me on the remedy, then I would address you on why the correct answer is to make a different finding from that which the Upper Tribunal reached. I would start with the lease provisions, but of course we looked at those in some detail yesterday, so to avoid repetition, I'll move straight on to what in fact happened. I think it would be helpful to start with a picture both as to what happened and indeed then what the pleaded cases below were, although we did again refer to that to some extent yesterday. If we could start by going to the supplemental bundle, page 4, right at the beginning. You may recall that yesterday I indicated that in fact what happened here, as my submission happens in most cases, is there was a contractual notice served as well as a statutory notice. This is the contractual notice which was served and which was relied on, and in the second paragraph we can see in the last sentence clear reference to it being served pursuant to Roman numeral 5 of the lease in 5.8. That is the general termination right, as your ladyship and your lordships will recall from yesterday. That was served at the, on the 3rd of October 2022, and at the same time on page 6 we see the paragraph 31 statutory notice that was served at the same time. This, as you'll appreciate, is in a statutory form, as is required by the code as we saw yesterday under paragraph 31. And in paragraph 5 of that form are the 4 grounds replicated from paragraph 31.4 that we saw yesterday. And we can see that the A and B are crossed through, so C and D are the grounds relied on in this notice. C is what we commonly refer to as the redevelopment ground. Just pausing there, this replicates the wording, so we can look at it here just as easily as the code itself. That's where there is an intention to redevelop all or part of the land to which the agreement relates. So pausing there, the land to which the agreement relates does mean, in this context, the communication site. So there's an intention to redevelop some or part of that site. It then goes on, or any neighbouring land, so that could be the nearby land, but then there's this additional requirement, and could not reasonably do so unless the agreement comes to an end. So the two components for the redevelopment ground essentially are an intention to redevelop either the telecommunications site or nearby land to the telecommunications site, and that redevelopment could not proceed reasonably without the agreement coming to an end. Then there's also D, which is left in, and that is therefore also relied on, which is the imposition test is no longer satisfied, and we looked at that briefly yesterday. Just for context, the imposition test is that stipulated in paragraph 21 of the code, and it's that test which is applied when one seeks to impose rights on, for example, a new site. Under part 4 of the code. So we didn't go through the provisions yesterday. I don't think that the terms of it should trouble your ladyship or your lordships, but just for context.
Can I ask a question?
My lord, of course.
We've been looking at part 5, termination.
Yes.
And it talks about in relation to an agreement, which I think is it paragraph 9, which defines which are the qualifying agreements from memory.
Well, yes, so within part 2 that defines what an agreement is.
Yes.
My lord, yes.
So that made me wonder, what about an agreement which has been imposed? Is there a separate part which deals with the termination of such agreements? And the answer is no, because paragraph 20 in part 4 says that an agreement which is imposed
My lord, yes.
is an agreement for the purposes of part 2.
My lord, that's absolutely right. And without wishing to go back to yesterday, just to clarify in case...
So, can I just ask a question?
If
you have the flip side, if you have a consensual agreement, no need for terms to be imposed. As a matter, it may not matter, but does that 4th ground D, is it capable of applying to terminate?
It is, my lord, yes.
Yeah. I suppose the philosophy being that you encourage agreement, but it's in the context of if there were to be a dispute, the paragraph 21 test would fall to be applied.
My lord, yes. So you've got the acquisition.
So ground deed,
It is
the
available.
paragraph is applicable to a consensual arrangement.
My lord, yes, absolutely.
Thank you.
Absolutely. And the flip side of that, perhaps just to clarify what was said yesterday, obviously I was focusing on contractual break provisions that had been agreed between parties, and for good reason, because that's the situation we're in here. But the same would be true if the tribunal imposed a conditional break clause as part of its agreement. Then the same dispute between my learned friend and I would arise as to whether the satisfaction of those terms actually imposed by the tribunal would have to be satisfied or not.
That's paragraph 23, isn't it, which sets out what terms can be imposed by, or was it 22, I forget.
We can go to, if you like, my lord. It's there's no, I mean, you've got the grant of code right on the terms specified by the tribunal. That's quite a broad range.
But the tribunal has to say when the rights will come to an end, and it's also given a discretion to effectively put in a break clause.
Absolutely, my lord, absolutely. And you will often see a classic example would be a redevelopment break, where often site providers say, well, we don't want an agreement either at all, or we're only willing to have a short one, but if it's going to be a classic sort of 10-year, 15-year term, then we want to have a redevelopment break at year 3 or 5 or whatever it is.
So if there were to be an imposed agreement, including a break clause, say on redevelopment grounds, or some of the grounds we have in 5.8, your submission is the same issue would arise.
Absolutely, my lord. Absolutely. So I focus on consensual because that's our position, but it's exactly the same with regards to impose. Absolutely. So again, the same position applies in terms of my learned friend's case, as I understand it, is if the tribunal had imposed a conditional break clause, my learned friend's case is that the site provider would not in fact have to satisfy those conditions that the tribunal itself had imposed as part of the terms of the agreement. We say they would have to, just the same as they have to on a consensual.
Subject to what he said on the other side, timing only.
Of course. Subject to that point, precisely. So yes, and to answer your other question, yes, ground D can be relied upon in either scenario, and that is of course the position here. So that's the notices that were served. If we can look briefly at the pleaded case.
Before we leave the notice,
Well,
the page 7 notes for completing this notice, and the date you propose, it says see note B. Is this prescribed language?
my lord, yes, this is part of the statutory.
Well, I just noticed towards the end of B, in setting the proposed date, we're told the effective paragraph 30 of the code should be disregarded.
Sorry, my lord, forgive me, wait.
Towards the end of note B, just above C, 4 lines, 5 lines up. It seems to be an explanation of the way in which the code works as regards to paragraph 30.
Well, my lord, yes, the wording there is the statutory wording.
Yeah. Thank you.
My lord, yes. In terms of, so then if we could go to the pleaded case below, if we go to page 21 in the supplemental bundle, we only have, I should say, as you may recall from yesterday, and you picked up from the papers, there was a pleaded statement of case, as they're called, by the respondent, which was then amended 3 or 4 weeks just before trial. We only have the amended version, but you can see the amendments that were made. I think there's a huge amount of controversy about what they included. We can see that, so page 21 is for context, is within paragraph 12, and is setting out my learned friend's case on, amongst other things, the contractual notice. And we can see at B that originally the pleading was, although actually it appeared later and is crossed through later on the page as well, but originally it was that the letter erroneously referred to the general termination right. So the reference to Roman 5 was said to be an error. And that was the position right up until, I'd say, 3 or 4 weeks before trial, where erroneously was then crossed through. The bit that didn't change was the reliance on the disposal ground. So the original case was that the reference to 5 was simply wrong, it was an error, and that, in fact, what they meant to say was the disposal ground. Of course, they said it didn't matter because they said that it didn't have to state which ground it was at all, a point which, as we discussed yesterday, the Upper Tribunal disagreed with them on, as to which there is no appeal. So originally it was as an error and they're relying on the disposal ground. Now what then happens with the amendment is the word erroneously is struck through, but the position remains, or the primary position remains, that they're relying and intend to rely on the disposal ground. And we can see that at C, where it is in fact replicated, where it says the respondent's primary case is on the contractual termination date, pausing there. That's a defined term from my earlier pleading, which means the break date. Essentially, that's what that defined term means. The disposal termination right was satisfied because, and then they set out the terms of the disposal, purported disposal upon which they were intending to rely. And at Roman numeral 3, we see carried through from the original pleading, in the premises the respondent was entitled to exercise the disposal termination right upon not less than 12 months written notice. So what we have in the original pleading is there was a mistake and we intended to be we intended to exercise the disposal right. And then the new case is, well, it wasn't a mistake. We did intend to rely on the disposal ground still. That hasn't changed. But then they go on to say, and this is the new D, which we see at the bottom of the page, if, contrary to that, it means that they couldn't satisfy the disposal right, then they were entitled to rely on the general termination right, i.e. that which they satisfied. And that's the point, or gives rise to the point that my Lord Justice Holgate and I discussed briefly yesterday, in particular with regards to the ability to rely on a failure. I think my lady and I also had a brief discussion on it. The ability to rely on a failure to get you back into ground 5, which we say one cannot do.
And
my Lord.
Contractual validity depends upon the condition being fulfilled at the break date, not at the date of the notice. Is that?
Well, one has to have in order to serve the notice, one has to have the reason. But then, yes, absolutely, you have to make out the break date. At the break date, you have to have made it out. That was my learned friend's position below, and that was my understanding.
And that's your position as well?
Well, yes. Because for some of them, there are, not for all of them as we looked at yesterday, for some of them there are preconditions that need the fall to be satisfied, some of which, as we saw with the disposal ground, might be satisfied at an earlier date, but others would have to be satisfied in between the two dates. So you would only ever know at the break date if you could, you might have the relevant intention, but whether you could satisfy it would be a later.
But in fact your case is that this doesn't depend on intention at all. You have to actually have agreed or disposed.
Well, with regards to the disposal ground, yes. I mean, down below we put them to proof of the satisfaction of that, and the Upper Tribunal found, well, we both parties have understood, found that they had not made out the disposal ground.
Because it doesn't depend on intention.
Because,
I understood that to be your case yesterday.
Yes, absolutely. So
it's not an intention condition.
No,
it's an actual disposal.
Precisely.
Or actual,
in respect
actual agreement made.
My Lord, yes. In respect of making out the disposal ground, that is correct.
Yeah.
You have to look at what the reason you're trying to do it is, which tells you which of the grounds you then need to make out. If it falls within disposal, for example, as in you're intending to make such a disposal, that's the reason you're trying to break, then the fact you then, by the break date, fail to make it does not suddenly mean you can rely on 5, is our case.
You should serve your ground Roman 1 break notice at the right time.
My Lord, yes.
Relative to the disposal.
My Lord, yes.
But when you say satisfied, are you talking about the circumstances which fulfill the relevant condition as opposed to the evidential process of showing that the ground is...
Oh, my Lord, yes, absolutely.
That's what I thought.
Oh, absolutely, yes. I'm not suggesting...
No, I appreciate it. I just wanted to be sure.
My Lord, yes, absolutely. Absolutely. I appreciate that would be a bit cheeky of me to suggest otherwise. Well, you can't, because they can't control the process of getting to that stage.
It depends upon the wording of the break clause in this particular case.
It does not, absolutely. So we then move on to how this was dealt with. If we could go to page 31 briefly, this is the context of our amended reply. And if we look at E, sort of the third way down the page, on page 31, this is paragraph 15.2E. Firstly, we note that they don't plead they could rely on the general termination right in circumstances where they could exercise or intended to exercise.
So could you give me the page again?
Of course, well, it's page 31 of the bundle.
Yes. Sorry.
And it's subparagraph E, which is... And so what we note is that they don't, or our understanding was that they didn't suggest at that stage that if they intended to exercise one of those grounds, that they could rely on the general termination right. And that's quite deliberate wording, because that goes back to my point, which is the fact that you then fail to do so doesn't mean
You can swap into
you
level
can swap
5.
it. My lady, precisely. And then the other way in which this was put, just briefly, if we go to page 99 in the same bundle, please, which is located within my skeleton argument for the trial. Paragraph 56 at the top of that page was addressing the amendment, and you can see just 2-3 lines up from the bottom, the second point I make is that where a party tries and fails to exercise a break right on one ground, it cannot rely on its own failure as a reason to exercise a general termination right. So that's the point made there as well. The other point, just to reiterate or note, is that it was, I think, accepted below, and certainly that was the decision of the tribunal, that where you can't rely on the general, as we've said before, you can't rely on the general termination right where one of the others is what you're intending, or is, what's available to you for what's intended. You have to go through one gateway. As my lord said yesterday, it would make the other grounds pointless if you could just pick to go. And another example would be if you wanted to, if you were required to undertake certain, to give a certain notice, for example, certain period, to consider, for example, under the alteration ground, whether you can do a workaround or not. If the fact you fail to do that means you can just go under ground 5 because you're giving less time, it obviously renders the whole thing pointless and cannot possibly what was meant. I'll give you the reference for that. That's at paragraph 15 of the judgment and page 78 of the core bundle. I don't propose to take you to it given time, but we can go there if it proves helpful.
CB 78.
CB 78, and
Thank
it's
you.
paragraph 15.
Got it.
So there were 3 potential witnesses from my learned friend's side. I say 3, and I say potential for this reason, as my lady and my lords will have appreciated from, I think, the written case and yesterday. There was permission for 2 only to start with, and 3 were provided. One was Mazzali, who was the in-house, a more junior in-house lawyer. She did give evidence. I'll come back to that in a minute. There was Mr. Prance, who was an estate manager for BT, and he also gave evidence. There was also Mr. Seller, who is a senior in-house commercial lawyer for BT, and ultimately he didn't give evidence. Now, as I say, BT had permission for 2 witnesses. The reference for that is this supplemental bundle, page 68. Again, I don't think we particularly need to go to it. It's not in. There's no controversy about that. But in advance of the trial, there was some controversy about whether they.
Sorry, is page 68?
Sorry, page 68 is actually the letter I'm about to take.
Yeah, exactly. It's a letter. It's not an order.
No, you're quite right. I'll find the page reference if it's helpful in a minute.
It would be useful. Just.
I'll find it, my lord.
Thank you.
Yeah, we'll get the page reference, but as I say, it's not. There's no controversy, so I'll move on while given time. In advance of the trial, the point was taken, and we asked, which is your third statement that you don't have permission for. My learned friend's side refused to identify which it was, and said they would apply for permission, though ultimately they didn't. And one of the reasons for that is this: at page 67, they started. They wrote to us on the 4th of December. So this is approximately just over a month before trial, and is also literally a matter of days before they apply to amend their case. Literally, I think 3 or 4 days before they write to us about that. And what they do at 67, but particularly turning the page to 68, is they invite 2 alternative concessions as a way of disposing with the need to rely on certain statements. And the first concerns Mazzali, and all I'd ask you to note whilst we're here is on page 68, where they say unless you concede, and then there's a concession they invite from us. This is a concession that wasn't given. But the reason they ask for the session, say they'll need to call Miss Alley in order to prove that the stipulation of the general termination right was an error. So this is a month before trial and several days before, literally 3 or 4 days before the amended pleading. They're still saying at that stage that the reason they're calling Miss Alley is to confirm that reliance on the general termination right was an error. But they then go on to deal with the evidence of Mr. Seller. That's the man the gentleman who didn't give evidence. And the concession they invite, as you will see, concession 2, is in respect of it's a combination of company structures and also confirmation that they're not a direct competitor, and is again aimed towards the disposal termination right. And we see that because they specifically say, underneath that, as you will see, our client will wish to call the evidence to establish its entitlement to rely on the disposal termination right. That evidence will be given by Mr. Seller. So again, Mr. Seller, the concession invited is rather limited and focused not on, I should say, on conceding that the disposal ground is made out, but simply that those terms. And the response to that is over the page at page 69, where that concession that concession 2 is offered in its limited terms. And as you'll see just underneath that, the third paragraph of that email from Mr. Merrifield to Ms. Russell is a request to confirm that therefore the client will not need to rely on the evidence of Mr. Seller. Now over the page at page 70 is the response. It deals with a significant number of matters, I should say, to do with bundling and preparation for trial, as you would expect at this stage. It is right to say that the request was made for Mr. Seller's statement to be in the bundle. That is because Miss Alley's statement cross-referred to it. But the confirmation is given, if you see the numbers 1 to 11, just underneath the second sentence, subject to the inclusion of the above documents in the bundle, we confirm our client will not rely on the evidence of Mr. Seller. And that confirmation is given. It then caused some surprise to us that at trial, my learned friend then sought, or offered, perhaps I should say in the first instance, to in fact call Mr. Seller to confirm his evidence. And if we go to page 163 in the bundle, just to locate you is in day 1 of the transcript. We can see just under the part that says the witness withdraws by E, my learned friend raises the possibility of calling Mr. Seller. And the discussion runs through really for the next 3 pages.
Sorry, to be fair, I think what I specifically said we'll have to do without Mr. Seller. And it was then the tribunal that raised the question.
Well,
That's what I was just going to
my lady, yes,
read out.
Great.
my lady, yes. If we continue over the page for a minute, though.
So we will do without Mr. Seller. Mm-hmm.
Yes, and then if we look, Judge Cook says you didn't apply for permission. Then Ms. Tozer says at the end, well, Mr. Seller's here, and if it's of assistance, he could confirm the contents of his statement. Over the page at 164, Judge Cook says that's a matter for you. If you need an extra witness, you need to apply for permission to call one. Ms. Tozer then says, in those circumstances, yes, I would seek permission to call Mr. Seller in order to confirm the statement in that bundle. I then make an objection where I say we conceded certain facts and therefore they said they weren't relying on it. And I asked for time, which is why there's then a subsequent short adjournment. At G to H on page 164, I explained that what I've effectively explained to my lady and my lord this morning about what had happened. And then over the page on 165 by C, my learned friend takes my point, says she's not sure there's anything contentious, but if my learned friend objects, then I do not think I can press the application. So she effectively withdraws the application for his evidence. And in fact, Judge Cook effectively confirms that's the right thing to do by saying, well, you said you wouldn't rely on it, so I think that's the end of it. So there's no doubt, and I should say, I don't think my learned friend is suggesting it otherwise. Mr. Seller's evidence was not relied upon for the purposes of the trial and was not called. And indeed, I think it's common ground that it ought not to have been taken into account by the tribunal.
Yes, and the skeleton on the other side.
Paragraph 54, precisely. I was going to give you the reference of Call Bundle, page 64. The decision then, as you will have seen, or I would say strictly over it because of the decision they make about the issue of ground one, but the decision made is that the contractual notice relying on the general termination right was valid. And we see that in a number of places. If we go to the core bundle, please, at page 91.
Sorry, core bundle page
91.
91.
And it starts really at paragraphs 98 and 99 here. And 98 is really just a summary of the issue. 99 talks about the use of erroneously in the original pleading and the change of that. And four lines up from the bottom towards the right-hand side, my lady and my lords will see, the respondent called evidence of Ms. Chowdhury, Ali, a senior legal counsel who drafted the break notice, explained her thinking. Her evidence was irrelevant. The thinking of the individual lawyer had no bearing on the validity of the notice. And then over the page they say, on the other hand, Mr. Sellers' evidence about the respondent's plans to close telephone exchanges and in specific plans for Kenton Road, see paragraphs 8 to 10 above, I'll go to that in a minute, my lord, is of central relevance in assessing the reason why the respondent wished to terminate the lease. And that is, in fact, if we go to paragraphs 8 and to 10, which is on page 75 of the core bundle, paragraphs they've referred back to, we see at the top of paragraph 8, the respondent's been making arrangements for some years to close the telephone exchanges. The following account is taken from counsel's submissions and from the unchallenged evidence of Mr. Seller. And then they describe in paragraphs 9 and 10 some facts about the closure programme, and in respect in paragraph 10 in particular about Kenton Road Exchange. It's right to also just record at this point that the tribunal made no reference in respect of this issue to Mr. Prance's evidence. So when we come to ground...
So what's the significance of that?
Well,
if they had done, what would they have seen?
Well, my learned friend, to a limited extent in her skeleton, has outlined information.
Exactly.
What they would have seen is that there was a closure programme. No one's doubting, by the way, that there was a closure programme. There's no one suggesting there isn't a programme. The question is, what's the reason why they want to terminate this particular agreement? And I'll come on to, and in particular, in respect of our argument about the linkage between the paragraph 31 notice grounds relied upon, and therefore, and the evidence available to the tribunal. The only evidence it points to when determining what the reason was is the evidence of Mr. Seller, which they describe as of central importance. And we know that they made the mistake of thinking that his entire evidence was agreed, which it wasn't, because when we look at the permission given, which is contained in the core bundle at page 98, this is the granting of permission by the Upper Tribunal, as is often the case. The tribunal, of course, can give its observations at these points. And I should note, what we don't see here, which perhaps I won't say unfairly, but sometimes in tribunals what we see is a re-explanation of what has happened, or an explanation as to, well, we would have done X and Y anyway, or whatever it is. What we see here is, at the bottom, having given permission, because they agree it's an arguable ground amongst all the others, we know what is said about the evidence of Mr. Sellers, and perhaps we could have expressed the position better. Our understanding was that Mr. Sellers' evidence was not relied upon because its content was conceded. Well, pausing there, of course, as I had taken them through the relevant documents, that's not correct. An aspect or certain facts were conceded. That's not the same as conceding its entire evidence. There was no factual dispute between the parties about the circumstances in which and the reasons why the respondent needed vacant possession. Well, again, that's, if I may say respectfully, slightly to truncate the position, because whilst there is a closure programme of sorts and there are documents to that effect, what we were looking at was the reason for terminating this agreement and how that fitted within the contractual provisions. And so in my submission, turning to ground 2 specifically, and relatively briefly, there can be no doubt, and I don't think it's seriously suggested by I think my learned friend accepts, as my Lord Justice Holgate notes as well, that there has been a procedural flaw or irregularity here. And in my submission, it is clearly an unjust one, because the decision is based pretty much entirely, if not entirely, then predominantly, upon the evidence that should not have been considered by the tribunal as is accepted. That, in my submission, is a very serious procedural flaw. It was based on a decision or belief, erroneous as it was, that the entire contents of the statement had been conceded, which was not correct. And of course, to the extent that the tribunal or my learned friend wanted to rely on that evidence, then an application for permission to adduce it should have been brought, we say in better time than at the trial. And we ought to, in those circumstances, we would have had the opportunity to put to him questions such as whether the real reason was because they wanted to undertake works, for example.
Because
The real reason they wanted to terminate our agreement was because they needed to undertake works. Because the paragraph 31 notice, and this is the point I'll come to in ground 3 particularly, but in the paragraph 31 notice, they are saying that they have an intention to undertake works.
Works for what purpose?
To redevelop. Now, my understanding...
And not works to facilitate a surrender.
Well, it might be works to forgive me, yes. When I say redevelop, I mean redevelop includes, we say, stripping out.
Yes.
And my learned friend must say that too. She must say that because she wants to rely on ground C. And in order to make out ground C, as we discussed briefly yesterday, my learned friend's client will need to show that they have an intention that they will undertake works which require our removal. So whatever they may be doing at the end result, I mean, we say, just to skip slightly ahead, but to deal with it at the same time, hopefully efficiently, that when you're looking at what the reason is in the contractual provision, and particularly the reason whether you can rely on ground 5 or not, and in how this ties in with the alteration ground, if you're saying, as they are in their paragraph 31 notice, and as they will do before the Upper Tribunal at a later stage, if the litigation continues, they will be saying, we intend to carry out certain works, whatever they are, and in order to carry out those works, we reasonably need you to leave, because we reasonably need the agreement to come to an end. That's the ground they have to make out. So what is the reason that they are terminating the agreement? Well, we know under the code, the reason they're terminating the agreement is because they need to do those works.
Well, I understand the point you make about the statutory grounds having to be consistent with the contractual grounds. But as I understand it, your factual case before the tribunal was that what they were proposing to do was works. Therefore, it should have been alteration ground relied on. And was the tribunal wrong to say that it was common ground that the reason that those works were going to take place was in order to be able to give vacant possession, so as to surrender? Because the two aren't inconsistent.
No, the two aren't inconsistent. I appreciate that.
And we'll come on to the paragraph in the tribunal's reasoning which you'll criticise, which is if it was alteration for the purposes of surrender, the alteration is incidental. But was there actually a dispute as to whether the reason was do some works in order to be able to give vacant possession?
My Lord, right to say there was no positive case run to the contrary. There's no case run to say actually you're doing these works because you want to develop them into flats yourself, or for example, or anything of that nature. So to that extent, there was no positive case. Is my answer to that. We weren't running a case that they were saying something different. The problem in my submission, my Lord is of course ahead of me in terms of where I'm going in terms of the tribunal's reasoning. But the difficulty, we say evidentially, is that the tribunal, in reaching its conclusion that those works were, for example, incidental to and therefore effectively should be overlooked to look for the final purpose, was the reason they gave, and the only reason they gave, was the evidence given by Mr. Seller, which was the evidence they shouldn't take into account. So we say it did lead to an unjust conclusion, and that's, of course...
The only evidence given, dealt with by Mr. Seller, that they shouldn't have been taken into account was on what point?
Well, on the question as to what BT's purposes were or intentions were when...
Namely?
to carry out the telephone exchange handback programme, and to Telerail, which is its. I mean, it's actually a very complicated, slightly complicated structure, which we don't need to go into. In terms of
he's the only person who said that programme specifically applied to these premises.
No, that isn't correct, my lord. Mr. Prance.
That's the impression you were giving me.
That's what I was going to go on to.
Sorry, he's
said against you that there was other evidence of this issue in any event.
Right, yes. Insofar as my position is, insofar as there was evidence of the exchange program, undoubtedly, but it was Mr. Sellers' evidence which addressed specific. I mean, we can go to the three statements, but Miss Ali dealt with what she meant when she signed, when she filled in the notice, and her evidence was said to be irrelevant by the tribunal and wasn't taken into account. In respect of Mr. Prance's evidence, there is a reference I can find where he confirms he doesn't remember. Perhaps if we go to that briefly.
Well, can we just know what the case is first?
Sorry, of course.
I'm having trouble finding where the gap is on your case. It was your positive case that there was an intention to carry out alteration works, because you said that's the right one. There was evidence of Mr. Prance, have I got this right, that the purpose in relation to this site was to enable the closure programme involving handbag.
That there would be works that would be done first.
Yes.
And then that it was part of that programme. Precisely.
So forget Mr. Sellers' evidence. What is it that's missing in the evidence to support the tribunal's finding that the purpose was to carry out works in order to be able to surrender the lease with vacant possession? Well,
insofar as there's a gap, we say it's because Mr. Prance's evidence. Can I take you to one passage in the cross-examination that may assist in answering that question? But essentially, there were three witnesses. If you discount Mr. Seller, Mr. Ali's evidence was said to be irrelevant by the tribunal. And Mr. Prance said, in respect of his discussions with Miss Ali about what they were intending to do, he couldn't remember. That's that passage in the cross-examination I'll take you to. And so the evidence from the witnesses was not, in my submission, sufficient to reach a conclusion that the purpose was to do this. Now, as my lord anticipates, when we get to ground 3, I say they reached the wrong conclusion. And because the reason they reached the wrong conclusion is this concept of ancillary or main purpose, because the contract is saying why don't
I'm just focusing on your evidence.
The simple question is, there is said to be a gap which was filled by Mr. Seller, which was not otherwise filled. What was it?
Well, my lord, I think perhaps if we go to...
well, can you not tell us before we look at anything, then we know which way we're going?
Well, the gap was, in my submission, that there was evidence that there was a closure programme, and there was evidence that there were works to be done, but there was no, in my submission, no evidence to explain that the reason that they needed to terminate this agreement was in order to carry out, to give effect to that closure programme versus needing to do the works.
Sorry, would you just say that again?
That's not a dichotomy.
Well, in my submission,
it can be both, and the tribunal found that it was both, but one was incidental to the other. The latter conclusion, I know you challenge.
My lord, yes.
Evidentially,
yes. Well, my lord,
it's not an either or, is it?
Well, my lord, in my submission, it might well be, insofar as that I absolutely accept you can have more than one. I mean, the ultimate intention presumably might be said to make money, and that's not one of the grounds either. You know, I accept that there might be a multiple-stage process. But for example, had Mr. Seller been called, he might well have been cross-examined on, or had we understood Mr. Prance's evidence to be dealt with in that way, we might well have been able to put that actually that the work, or put with to a different extent, that the real reason was the works that they wanted to do. That's why they needed to get us out. That's what they were intending. Because we did have this question about what was their intention, which ground did they intend to go through.
Sorry,
my lord.
I really want to make sure I understood it.
Of course.
I started to write down your answer to the question. There was no evidence to explain the reason to terminate the agreement. And would you mind just finishing so we can get a note of it?
My lord, yes. The reason Mr. France didn't give evidence in my submission that the reason to terminate the agreement was to give effect to the exchange programme rather than to carry out the works. And we say to the extent that the tribunal relied on Mr. Sellers' evidence, which it ought not to have done, and didn't purport to rely on Mr. Prance's evidence at all in that respect, in reaching that conclusion, gives rise to the gap my Lord has asked me to identify. And so that leads, we say, to a serious procedural and unjust result, where the tribunal felt that there was evidence upon which it needed to rely in reaching that conclusion, and did so, which it wasn't entitled to rely upon. Now, to the extent that despite the procedural breach, the question is, well, it was still it may have been entitled to come to that conclusion. If that's the conclusion of this course, of course, then in respect of ground 3, as my Lord has already anticipated, we then go on to say that they simply reached the wrong conclusion. And the primary reason for that is this. In the paragraph 31 notice, they have stipulated, as I spoke with my Lord a minute ago, that they have an intention to carry out works which require the agreement to be terminated. Reasonably require the agreement to be terminated. If that's not the case, then they won't be able to make out their paragraph 31 ground. And taking it at face value that that is the intention they genuinely believe they have, if I put it in these terms, when serving their notice, then we say, in answering the question, what's the reason you want to terminate the agreement? It is inconsistent at that stage to say you want to terminate the agreement so you can hand it back. Just the same as we're being consistent to say we want to terminate the agreement because we think we're going to make more money that way, or because our shareholders want us to divest of property, or whatever it is. The reason you need to get the property back is to carry out those works. And we know that because that is what they're saying in paragraph 31. That is what they must be saying in paragraph 31. And so if that is the case, in circumstances where they do have an intention, they say, to carry out works which reasonably require the agreement to be ended, that is mirrored by the alteration ground in Roman numeral 2 from clause 5.8. Not word for word, of course, it's not a copying of the statutory provision. But in those circumstances, as we discussed yesterday and earlier, where they have to fall within a contractual gateway, and ground 5 is only available to them if their reason for seeking to terminate the agreement. And in my submission, that's effectively...
Can I see if I'm keeping up? Let's say you've got a simple case where they rely upon the redevelopment ground statutorily for the purposes of paragraph 31, and in terms of the contractual break clause, they have no other reason for exercising the break clause other than to redevelop or to carry out alterations. Your argument is you would have to bring yourself within subparagraph Roman 2, and you couldn't rely on 5.
Yes.
Yeah. Let's imagine the other part of my question is this: you could have a situation, could you not, where the landlord in this case, the provider, in fact, as a matter of fact, is able to rely on more than one contractual ground. And if that's the case, admittedly, he can only rely upon the statutory grounds which paragraph 31 allows, but there's nothing to stop him as a matter of law relying upon whichever break clause ground he's able to rely upon, if there be more than one.
Well, my Lord,
true or false?
Well, in the hypothetical, I absolutely agree, it must be right. But the question isn't to look at, in my submission, for example, taking works. When everyone does works, they do that for a reason, right? It might be to make money, or it might be to facilitate a larger shop, or it might be to facilitate, if it's not non-commercial premises, to facilitate a more pleasant abode, whatever the position is. This isn't getting at your sort of ultimate motives, I say, or getting into that sort of how far you can take that.
All I'm putting to you is, if you've got a situation where the landlord in this case is able to rely upon Roman 1 and Roman 2 of clause 5.8, then there's no legal principle, is there, which says he's got to put down Roman 2 in a break clause notice rather than Roman 1.
No, my Lord, that's correct. Right. Though if you're in a situation where Roman 5 is only applicable where the others don't apply,
That's a different point.
which is the position, then if what you're intending to do, and of course we know here, in fact, that they'd always have to do, well, the position we're told, and their cases I understand is they'd have to do those works in order to hand back. If that's the position, then you come back to what is the reason this agreement needs to terminate. And the reason from their perspective, and the reason it needs to terminate from their perspective, is to facilitate those works. Nothing else that they might want to do afterwards could ever follow, because they need to do those works first. And that's, as I understand it, the position that they have adopted and said, and that must be the position they adopt for the purposes of paragraph 31C. So
I'm not sure you're quite meeting my Lord's point. Suppose that one were fulfilled. There's been an agreement to dispose of it, and the agreement says, before the completion date, we will carry out the works of stripping out in order to be able to give you vacant possession.
Yes. Then in those circumstances, you type 1 or 2.
Would they not be entitled to say there is a statutory reason for termination, namely we've got to do the stripping out and get rid of your equipment. But from a contractual point of view, one is fulfilled, and that's the one we're relying on. We have agreed to dispose. As I understood it, that's my Lord's point. Is that right?
Well, I accept that, apart from the ground 5 is different, because grounds 1 and 2 aren't said to be exclusive of others, or don't require you to exclude those.
No, not on ground 5.
But in respect of 1 and 2, I would accept that, yes.
But it illustrates the point that there may be more than one reason for terminating, one of which may fall within the statutory purposes, and another of which may fall within the contractual entitlements.
My Lord, I accept the principle as possible. My point is, I return to the fact that because the ground they relied on was ground 5, and that is exclusionary of the other reasons. So if the reasons you have fall within that, in my submission, that's where you go to. Not least because, as I say, in order to carry out the works, they're saying that in order to carry out the works, right or wrongly, that's a matter for the tribunal another day, but if we continue with the litigation, but if they're saying that in order to carry out those works, they will need possession effectively, or will need the agreement to come to an end, and that brings them within ground 2. If that's the reason, and that is, in my submission, the reason that they need to do it.
They can't rely on letter 5. That's your simple point.
It's a simple point. It is a simple point.
Okay.
My lady, precisely.
Again, just to make
But far better than I
I'm
did.
keeping up, you have told us, I think, and I understand, that the tribunal hasn't yet determined, in terms of paragraph 31, whether ground C or ground D is satisfied.
That's correct, Madam.
And that's for the future. We're only looking at preliminary issues. In terms of the ability to rely upon a break clause, if that has to be satisfied, presumably the same applies there. The tribunal hasn't determined, by looking at evidence, whether the alteration ground is made out.
Well, my Lord's right to say that the tribunal hasn't determined that. Of course, the alteration ground wasn't in fact relied upon. Yeah. Well, the tribunal hasn't. My learned friend didn't seek to rely because she hasn't. So we've got to remember the pleaded case is that the general termination rights was written. That's either a mistake or alternatively, they nonetheless wanted to rely primarily on the disposal ground. If that was wrong, then the subsequent amended case was, well, we could then have relied on ground 5. So there was no opportunity for the tribunal. The tribunal, we said that because of their intention, they ought to have relied on ground 2, because of course the thing my Lord has to remember is it's not just about whether you can make out the ground, it's about what your reason is. So it might be your reason is to carry out, let me postulate a situation. My reason is to carry out works, which I say require me to terminate the agreement so that I can come on and do those works. That's the reason, which means I can't rely on ground 5, I have to rely on ground 2. Now I may fail to satisfy ground 2 in a number of ways. One is it might be said, actually the works I want to do, I can do with you in situ. Turns out I don't need to get you out at all for those purposes, in which case I would fail. Another way would be if I hadn't complied with the preconditions we looked at yesterday. So I don't give you the opportunity to do a workaround, or I unreasonably say I can't work around you. And so, my Lord, in those circumstances, the reason would bring you within 2. You may not ultimately satisfy it. But I absolutely accept, my lord, that there's been no determination.
Well, one of the reason why I asked this, about 5-10 minutes ago, you were advancing a submission that from a temporal perspective, there are works which, as you understand it, need to be done before the surrender can take effect.
That's what I
And
understand
I
to
can
be
see
my
how
own
there
friend's
might
position.
be an argument about how, if that be factually correct, how that then is to be analysed in terms of the effect of the break clause
My lord, yeah.
and the date at which you can either rely upon ground 1 or ground 2. But as soon as one starts to get into that sort of debate, I'm rather inclined to think this is not a matter which was before the tribunal, and therefore not a matter for us at this stage.
Well, my lord, I'd say a couple of things in response to that briefly, if I may. Firstly, what was before the tribunal was that because they intended to do works, I should say, of course, they can only do works before they hand back, because once they've handed back, they won't have right.
Forgive me for raising this. It goes back to my concern about what on earth is meant by validity of a notice. It can cover a range of different things, from the bare format of the notice to the way it interacts with the lease.
Well, my lord, I absolutely accept that.
One has to be very careful about drawing up preliminary issues.
My lord, I absolutely accept that, and of course you I think rightly commented earlier about, or maybe it was yesterday, that the Upper Tribunal had noted its this issue about validity. In fact, I remember going into the trial, there was a question asked at the site view about just double checking we're not also dealing with grounds C and D when we start tomorrow, because obviously one might use validity to that full extent that it means whether you've actually satisfied those grounds or not. But of course, that wasn't the position either party had taken or understood by the first tier tribunals drawing up of or approval of the preliminary issue. Secondly, my understanding of my learned friend's position, but she'll correct me if I'm wrong when she's on her feet, but my understanding is that it was and remains their case that there are works that they will do or need to do prior to the surrender. And that is why, and indeed that in some respects must be the case to be consistent with paragraph 31 4C, because they will only have the right to do works until they surrender. Once they've surrendered, they won't have the rights to do those works. So in order to get, and the test obviously under 31 4C is whether they reasonably need to end our agreement in order to do those works. And I should say it would be for them to do those works, just the same as it is under ground F. It's the landlord, not someone else.
This part of the case, does it boil down to this, that there is something in by the way, we haven't got Mr. Sellers' evidence, have we?
I don't think so, no, on the basis
but
it was
there's
agreed.
something in a document we haven't got, which the tribunal's taken into account in a way which have materially affected their determination. I'm beginning to wonder how I can think about this.
Well, my lord, the other point I was going to make, of course, is my invitation to your lordship and the court is to remit the matter back to the Upper Tribunal to make its own determination. Because what is, I mean, the point I would...
I'm sorry, but to make good at the ground of appeal, there must be something in this document we have not got, which if we were to look at, you could say, oh, well, you can see how that was taken into account. It was material to what the tribunal decided in paragraph X. And equally, there was no other material to deal with that point. But I'm struggling to see this at the moment.
Well, I don't have the statement in the bundle, so I can't take your lordship to it, of course.
This all arises out of paragraphs 93 and 94 of the
My lord, yes.
doesn't it?
Yes.
Which is the critical finding. It's adopted later, but this is the critical reasoning as to why your alteration argument was rejected. 93, claimant argued that 5's not available because it intends to strip out Kenton Road Exchange, remove all its contents. That is alteration. Respondent says stripping out of the premises is incidental to the real reason why it wants to end the site lease in order to surrender it. Paragraph 95, we agree with that analysis. As I understand your point, it is essentially if you've got two reasons, first you need to strip out, and that's in order to give effect to the ultimate reason, which is surrender of the lease.
Yes.
If you can ignore the stripping out for lease purposes, then you'd have to ignore it for statutory
My lord, yes.
4C purposes. And since the whole premise of the argument is that there's been a valid 4C notice,
That must be what they.
that,
Must be what
I mean, is that
My lord, yes.
is that the point essentially?
That's the ground 3 point, absolutely.
Yeah.
In a nutshell, my lord, that's absolutely correct.
That's not dependent on the unfairness point.
No, because and there are two grounds that are raised. So ground 2 is the procedural unfairness, and ground 3.
So we needn't.
So well,
If you're right about that,
if you're with me on ground 3, you don't need to consider ground 2.
if we were with you on that,
Then
it wouldn't matter.
The procedural unfairness wouldn't matter.
Mr. Sellers' evidence is effectively sufficiently found elsewhere in Mr. Prance's evidence.
It would make no difference. It would make no difference to that, my lord. Exactly. Exactly.
And we do have Mr. Prance's evidence.
We do have Mr. Prance's. Yeah, let me give you the references for those.
Yep.
We have Mr. Prance's evidence, which is at. No, that's the wrong page. It starts at page. Well, there were two statements. In fact, it starts at the first one starts at page 44 in the supplemental bundle, my lady, and the second statement is contained at page 62, also in the supplemental bundle.
And you were relying, I think, a little while ago, upon cross-examination of Mr. Prance.
Yes.
And rather than take us to that, perhaps you could give us the reference.
My lady, yes, it's at supplemental bundle 149 and supplemental bundle 152.
149, 152.
My lady, yes.
Thank you.
And in short, he confirmed firstly at the first stage that he wasn't the decision maker, and secondly that he couldn't remember his discussions with Miss Alley in advance of the service of the notice.
Thank you.
If I could just turn my back for a moment. My lady, they conclude my submission subject to those in reply. I'm pleased to say just in time. So
The guillotine was about to drop.
my neck remains just for another day. The only point to note is my Lord Justice Holgate asked for a reference for the order from the about evidence. I'm told, in fact, it's not in the bundle, but I don't. It wasn't in dispute that there was such an order. If the court would like to see it, I'm sure we can arrange for a copy.
No, don't worry. Thank you.
I'm grateful, my lady.
Thank you very much indeed. Miss Jovin.
Thank you. My lady, my lords, I'm going to go back to where we were yesterday and therefore take the orders in which my learned friend took them. That means going back to paragraph 31 of the code and thinking about the statutory regime first. And we say that there are a number of errors in my learned friend's analysis. And the first one is the suggestion that there is a presumption that in parallel with the statutory scheme, the contractual scheme should subsist as far as possible. My learned friend took my lady and my lords to the Child Poverty Action Group Authority, and we say it's clear from that, specifically from paragraphs 27 and 31, that the true position is it's a question of construction of the statute using ordinary principles to determine the extent to which Parliament intended the contractual or indeed the common law schemes to subsist in parallel with the statute. And I think it is accepted, I think my own friend accepted that it's the same. Part 5 must operate in the same way, whether we're talking about overriding the common law notice to quit regime or a contractual break notice regime, that it must be doing the same in both cases. And the questions before the court, of course, are whether the paragraph 31 notice is valid. And there are 3 sub-parts to that, if one likes. That's to say whether it's valid if a contractual break notice is not served, whether it's valid if a contractual ground is not stated, and whether it's valid if contractual conditions, whether preconditions or conditions subsequent, are not satisfied before the date on which the paragraph 31 notice is served. Those are the questions. Now, I accept that it may also be useful to think about
So
whether...
could you just give me those again?
I'm so sorry.
To get them down
Yes.
accurately.
Whether the paragraph 31 notice is valid, firstly, if no contractual break notice is served. That's my own friend's case. He says a contractual break is required. Secondly, if a contractual break notice is not required, but whether a contractual ground must be stated at the time of serving the notice. The reason that arises is that's what the Upper Tribunal found, and we say that's wrong. And the third thing to
So that would be stated in the paragraph 31 notice?
Well,
or
in a separate letter, I suppose,
yes,
is what was envisaged.
That's the second.
Yes. And the third is to what extent contractual conditions need to be complied with prior to the service of the paragraph 31 notice. And I think my own friend said both conditions that need to be satisfied before the contractual notice and upon expiry of the contractual notice all need to be satisfied before you can serve a valid paragraph 31 notice. So those are the issues of statutory construction which arise. There are a number of similarities between the answers and the approach, we say. What doesn't arise strictly is whether once you've got a paragraph 31 notice, you have to do anything else in order for your termination to be effective, because that's not before the court. But I'll talk a little bit about that because my own friend's submissions in relation to conditions give rise to that question. And also, even further down the line, what's not before the court is whether, assuming you've got a valid statutory termination, there is any other contractual remedy because you haven't complied with other conditions in the contract. And again, not before the court, but something that might be useful just to say a little bit about in order to understand how the statutory scheme is supposed to work. For present purposes, what we say, of course, is perfectly possible to conclude that Parliament intended to oust the contractual and common law termination provisions and replace those with a statutory scheme without concluding that Parliament intended to oust any separate contractual remedies, monetary remedies, and that sort of thing. So, my learned friend mentioned yesterday in passing that in the bundle of authorities, we had put in an extra few sheets of agreed propositions. They're matters where we haven't included the authorities in the bundle because he and I were at one, but they are there and we do have the authorities available should that be required. The reason I mention those now is that is where we have dealt with, there are no contentious authorities in relation to the principles of statutory interpretation. We've agreed those principles. And what I would stress is, of course, that the wording of the statute is very important. Of course, one looks at different formulations, but my own friend and I think, are at one, that it is to be given considerable weight. And we say my own friend's second error was to fail to give adequate weight to the wording of paragraph 31. If I could briefly take your ladyship and your lordships back to paragraph 31, which is tab page 13 in the authorities bundle. We say paragraph 31(1) is really very simple. What it says is, a site provider may bring the agreement to an end by giving a notice in accordance with this paragraph. We say that's clear. That's what a site provider has to do. They have to give notice in accordance with this paragraph. So long as you can and do comply with the requirements of paragraph 31, which we'll come on to look at, that's all you've got to do. There's no room for adding in anything else to what the site provider has got to do. Whilst on that page, I would also mention, my learned friend mentioned briefly about the prescribed form. The court will see that paragraph 31(2)(a), the notice has got to comply with paragraph 89. That's the paragraph. I'm afraid we failed to copy that, but that's the paragraph that says the notice has got to be in the prescribed form. My learned friend took the court briefly to the prescribed form notice in this case. There's no dispute it was in the prescribed form. It's at pages 6 and 7 in the supplemental bundle. And I just make this point briefly. There's nothing on the form to suggest that the site provider needs to do anything other than serve this notice. it in fact suggests in paragraph 6 of the notice that the code agreement will come to an end unless you take action by serving counter notice and then issuing proceedings. More than that, the notes which are given to site providers on the prescribed form, over the page at page 7, are positively misleading, if my learned friend's case is correct, because what they say about in the paragraph had started in accordance with the second bullet point. So it's talking.
So you're on page.
I'm sorry, I'm on page 7.
Yep.
And there's guidance given about how the date is to be calculated, and we'll obviously have to look at that. But for present purposes, I just wanted to highlight the paragraph starting in accordance with the second bullet point. So this is the bullet point that we're talking about. One of the following conditions must apply on the date when you propose the agreement should come to an end. So at the expiry of this statutory notice, one of these conditions has to apply. And the second one is you are able to bring the agreement to an end, e.g. by giving notice. So if my learned friend is right, that actually what a site provider's got to do is serve a contractual notice and comply with all the contractual conditions and so on before they can even serve this notice, the guidance that's given here is completely misleading.
Just to be clear about the status of these notes, they've been laid down by the regulator.
So Ofcom have produced these prescribed forms in accordance with...
Yes, because in some cases you come across regulations which set out the prescribed forms. We're not dealing with delegated legislation.
It's not, no, it's not
Sometimes
secondary.
they're even before Parliament at the same time as the primary act,
Yes,
legislation.
no, that is
it's
not...
all subsequent to the
Act itself,
okay.
because there is a requirement in the Act to use a prescribed form.
Yes,
so the Act clearly envisages there will be a prescribed form, but I can't say that no Parliament looked at this. All I can say is this is how Ofcom
Yes.
understood the thing to work, and one might expect Ofcom to have had some understanding of what was intended, and indeed somebody to object if the prescribed form was hugely misleading.
I'd be grateful, Mr. Hughes, if you would spell out what you've just said about the paragraph which begins in accordance with in relation to the second bullet, because the second bullet says, after the time at which, apart from paragraph 30, the code rights to which the agreement relates would have ceased to be exercisable, or to bind you at the time when, apart from that paragraph, the agreement could have been brought to an end by you. And then there's reference. I think that what Miss Elise is saying is could have been brought to an end by you is a reference to something contractual.
I think what Miss Elise says is what that requires is for you to have actually served your break notice before you serve this notice.
Yeah. And why, therefore, do you say that the paragraph beginning in accordance, I know you've already said it, but if you'd be great, I'd be grateful if you say it again.
I'm so sorry.
It would be clearly misleading in those circumstances.
Well, because firstly it says in Roman 2 you're able to bring the agreement to an end. It doesn't say you have brought the agreement to an end, you have served your notice. It says you're able to, which is consistent with our construction on the wording, which is just simply that you have a contractual right, not that you have. That's the difference between my learned friend and I.
Not that you have what?
That you have exercised your right. That's what he says. He says you must have exercised your right before you serve this notice. Whereas I say you must have been able to.
But it's saying in relation to Roman 2, these are the conditions which must apply on the date when you propose the agreement should come to the end. And it then says, Roman 2, you are able to bring the agreement to an end. Prima facie, that would appear to mean able on that date, then
Yes.
to bring the agreement
Yes,
to an end. E.g. by giving notice must mean e.g. by having given notice, mustn't it? Not giving notice at that date.
Well, then it would say you have brought the agreement to an end. And what my learned friend's case is my learned friend's case is you must have served a contractual notice before you give this notice. What these notes say is, on the date when this notice expires, you must be able to bring it to an end. And those things are completely different.
You must have been able to.
Well, that's not what it says. It says you are able to.
Could have been brought.
Well, if you've got a 6-month notice provision, we're not talking about giving the notice at the end of the period, are we?
Well, no, I don't say that.
No.
I
So
say...
I didn't really see how. I mean, it may not matter very much because this isn't an aid to statutory construction. But I don't myself see why what's said here supports your interpretation.
Well, if my learned friend is right, what I think they might have said was one of the following conditions must apply on the date you give this notice, not on the date you propose the agreement should come to an end. It would have said on the date you give this notice, you must have served a break notice. That would have been really simple to say. That's what he says it means, and that would have been really simple to say. You must have served a break notice before you give this notice, if you rely on a break clause.
Speaking for myself, it appears to say, look at the expiry date you've put in your notice.
Yes.
You've got to have been able to bring the agreement to an end at that date.
Yes.
For example, by having given a notice to terminate, a contractual notice to terminate.
Well,
how else do you read it?
By having been able to give a contractual notice.
By giving, meaning by having given notice.
Well, but it's prefaced by you are able to, and we don't need to argue about this. But even that is much closer to my construction than my learned friend's construction. Because
As you began this submission, if he's right, this is misleading.
yes.
To which one might say, so what?
Well,
It's
very
not
well.
going to-
Very well.
It's partly my fault, and I apologise. I drew attention.
I went down the rabbit hole. I'm sorry.
I just happened to find the way it was set out in the following sentence helpful, but not obviously.
All right. Well, it's obviously
Not
caused more
obviously.
confusion than it needed to.
The following sentence, but it's not worth looking at that if the preceding sentence gives rise to this difficulty. So sorry.
So let's go back.
All right, let's go back then to the normal sort of approach of the order of my learned friend's submissions and start with policy. I'll come back to wording, I'll follow my learned friend's order and I'll start with policy. We say there were two errors here. The first is that my learned friend was wrong to focus on the policy of the code in general rather than the policy of this particular provision. That is one of the agreed propositions of statutory construction on our list at paragraph 1.4.
But any provision in any statute
Needs to be read
in context.
Absolutely. But if we're looking for the purpose, it's right to consider the purpose of this provision. Why is this provision here? So I'll do that. But we say, in any event, my learned friend was wrong about what the purpose of the code was. He wrongly characterised that. And so we'll look at the purpose of the code as a whole as well. Now, my learned friend took the court to EE and Stevenson for an account of what the purpose of the code was. And of course, that was just in the context of what mattered for that particular case, i.e. what sort of, whether a site-specific reason for getting a new agreement was required or not. That's not what arises in this case. I say the right place to look for the policy of the code is in the Law Commission report and the DCMS reports. And we've got those in the bundle. If I start with the Law Commission, it's at 279 in the supplemental bundle. And we'll start with the general mischiefs that the code was intended to remedy. And that's 279 at 1.9. We can see what they say. It's clear to us from the beginning of the project that the 2003 code is in need of reform for three main reasons. First, it's complex and extremely difficult to understand.
So we'll have another go at confusing everyone.
But there was an aim. Secondly, the approach is outdated, bearing in mind technological changes. And thirdly, over the page at 1.11, there's concern the code is making the rollout of electronic communications more difficult. It goes on to explain why the 2003 code seeks to regulate the effects of agreements to confer specified rights and to back this up with a system for compulsion, where agreements cannot be reached. Yet it lacks clarity on several important matters, and they look at what those matters are, and the last of those is how the termination of those rights is to be enforced. This, together with the absence of efficient dispute resolution, considerably hampers its usefulness to both code operators and landowners. In addition, it's not clear that it strikes the right balance between those parties. So one of the mischiefs that the code was intended to remedy was the fact that the old code was complex and lacked clarity, and that lack of clarity was hampering rollout. Now, our construction, we say, is consistent with an aim to bring clarity, because we say all that a site provider needs to do in order to terminate the agreement is follow the statutory scheme. What my learned friend says is, no, it might say in the statute that all you've got to do is serve a notice, but actually you've got to do a lot of other things as well that aren't written down, and as I think we've established in our discussion this morning, can actually be quite complex to work out how to do and what you're supposed to do if you're a site provider.
You've got to do more than just serve a conforming notice in order to bring the agreement to an end.
Well, you've got to establish a statutory ground if put to proof.
Quite.
And then, yes, and then the agreement comes to an end.
That may be quite a complex matter.
Oh, absolutely, absolutely. And my own friend doesn't dispute that either. The question is just whether on top of that scheme, which, as your lordship remarks, already is not entirely straightforward for the parties to navigate, there's a whole nother level of requirements which are not recorded in the statutory scheme, and nobody would know they were there. So,
but as I understand your submission, a purpose is to introduce clarity.
Yes.
But clarity so that the rollout of networks is not hampered.
Yes, I absolutely accept that to
support the two together.
To support operator rollout was one of the things that was intended to be achieved. However, it's quite clear that Parliament did not intend that at all costs. It's not the case. It's a balance, exactly, my lord.
It's not the case. There's another factor that's referred to here, namely the public interest.
Yes, that too.
It's not just the position of because the public has an interest in the rollout of the networks.
They do, exactly. And that's why there's a general interest in having a clear code so that everyone can understand what needs to happen, so that rollout doesn't get held up. So the fair balance point, my lord, is important. If I can just report a few more documents on that. So page 303, we've got a DCMS impact assessment from 2014. And we can see, again, the problem under consideration. I'll perhaps leave the court to look at that. Again, it picks up clarity, but in the second box, what are the policy objectives?
I'm sorry, what is this?
It's a document drawn up by DCMS to explain what the impact of the legislation will be.
Did it accompany the bill?
I'm afraid I don't know for sure the answer.
It's in connection with the primary legislation.
Exactly, it's before the primary legislation is passed. There's a government, the department which promotes the document creates the department which promotes the bill creates an impact assessment which explains what the impact of the bill is going to be.
Because the legislation typically enacted in 2017.
It is.
This is the 2014
This is document. 2014. And then what happened in brief summaries, the Law Commission did their report. There was then this impact assessment in 2014. Then it was decided that actually the valuation regime which the Law Commission had proposed wasn't going to find favour, and Parliament wanted to change the valuation regime, which or at least consider changing it. So there was then another round of consultation after the Law Commission had reported, primarily on valuation. And then we get another impact assessment on page 306 in 2016, where it's then the impact assessment is redone on the basis of the changed valuation.
Is the paragraph you want still in this?
It's in both. So
why don't we go to
the policy objectives in 306 is adding clarity and certainty to all parts of the code. That's midway down the middle box. This one doesn't, in fact, say fair balance, but we've got the DCMS report. Keep going over the page. It's the ministerial forward to the report that went before the bill was enacted. So the first page is 311. And then
And what is the weight to be given to all this?
well, it shows at least what the promoter of the department promoting the bill was aiming to achieve. I'm simply trying to reinforce the point that my learned friend suggested, that the policy behind the code was simply to help operators. As my learned friend advanced the case, we could assume that anything that was in an operator's favour was going to stay, but any contractual terms that were in a site provider's favour were just going to get chucked out the window. That's my learned friend's position, that's what he says as a matter of policy is what Parliament was trying to achieve. And I'm trying to demonstrate that that is not correct. That it's quite clear they had in their minds that, as one would expect from a responsible legislature, that the legislation that they were going to promote needed to be even-handed, needed to take into account, as my Lord says, the public interest and the interests of both types of parties that were going to be primarily engaging with the scheme.
Which is the paragraph you rely on?
On page 313, the middle paragraph, these changes are just some of the highlights. The overall package of reforms being put forward strikes the right balance of interests between site providers, communications providers, and most importantly, the public interest. We say it's quite clear it wasn't intended to be a one-sided thing. And we say that the purpose of paragraph 31 is precisely to counterbalance the security regime that was being created for operators' benefit in paragraph 30 by giving site providers a countervailing termination right. And of course, if my learned friend is right that it was supposed to be completely one-sided and it was only supposed to benefit operators, then we didn't need paragraph 31 at all. We could have just said, oh, well, as soon as operators get any agreement, the site providers have no right to terminate it at all and they just get to stay there indefinitely. So it's quite clear it wasn't a one-sided show. And the purpose of paragraph 31 is to benefit site providers. And I say that is important when considering its construction. And the width of the right that's given under paragraph 30 needs just to be appreciated for a moment. Not only does it stop expiry by effluxion of time, break notices, it also stops and takes away the landlord's right to forfeit. So in any other commercial arrangement, if somebody doesn't pay the rent, then the landlord can bring the agreement to an end. There'll be a warning notice, of course.
So does it take away the right to forfeit?
It does. It does. It makes it subject to the same regime. You've got to give 18 months' notice. So it's a very fundamental interference with what otherwise would have been the position. And operators are getting a very significant benefit in paragraph 30 that we say is counterbalanced by a statutory termination regime that can be taken at face value.
I may be a bit rusty on this, but didn't the House of Lords say in Shiloh, Spinners and Harding years ago that the purpose of most forfeiture clauses is to operators' security, to obtain the performance of the obligations in the lease?
Yes.
And that's hence section 146, right to apply against relief against forfeiture and so on. Why can't that be given effect to alongside paragraph 31?
Well, because the reason it operates as security and it doesn't.
I mean, in fact, if it doesn't, that would be deleterious, wouldn't it? Because rather than having forfeiture in a sort of Shiloh, Spinners and Harding sense, the remedy would be to serve a Para 31 notice.
Well, yes, but then there'd still have to be statutory grounds. The statutory grounds, you'd have to prove.
But more, worse than that, what if you have potentially forfeiture on a ground which is not covered by paragraph 31?
Well, you can't. That's the point. You cannot.
That sounds
anymore.
breathtaking.
But yes, that's what I'm trying to explain, that this right that's being given to the operators is completely different from the 54 Act in that respect.
Yes, but a more nuanced approach might be to say forfeiture still is a remedy that's available. It's not excluded by paragraph 31.
Well, there's really, it's difficult to see. I think my own friend was agreed about this yesterday. It's difficult to see how that fits with the statutory wording.
Okay.
And of course, there is a difference between the wording here and the wording of the 54 Act, where the 54 Act specifically says the landlord's right to terminate by forfeiture is not affected by what we're doing here. It's not affected by this security. And that hasn't been replicated, despite what was taken, the amount that was drawn from the 54 Act as a starting point when drawing up this code. So it's clear, we say, that there was an overwriting, a significant overwriting of the contractual relationship between the parties by Part 5. And we say that when we're looking at paragraph 31, which is the part that's supposed to benefit the site providers in all of that, to make it a fair regime, one has to bear in mind that that's the purpose of paragraph 31, that clarity was important, and that if you are a site provider who is, let's say, not BT, that the more typical site provider is a rural landowner who might be a one-time player in all of this, who is getting, by way of rent under this, at the moment, I think that the tariff for a greenfield site is £1,750 a year. That's not enough to be taking expensive legal advice when you want to terminate.
I'm not sure that's relevant to how we construe these paragraphs.
Well,
is it?
My lady, I suggest it is, because I suggest that's why it's important that a site provider should be able to look at the code and understand what he's got to do. He should be able to look at it and say, I can take this at face value. What I've got to do is serve a statutory notice, make out my statutory ground, and that's it. And as I say, against the context of a desire to create something that was clear, I say it's quite unlikely that Parliament, in fact, intended to create a trap for the very people it was seeking to benefit by this provision. My own friend took the court to the explanatory notes. I don't think we need to go back to those. I just make 3 brief points in relation to the explanatory notes. The first is, again, there's an agreed proposition in relation to the relevance of explanatory notes. And we say it must be clear what Parliament intended before one can really get anything from the explanatory notes. The second point in relation to the explanatory notes is there are 2 versions of explanatory notes in the bundle. One is the version that was annexed to the bill, which we say strictly is the right one to look at, because that's the one that was before Parliament. We've also included the explanatory notes that are attached to the Act. The explanatory notes attached to the bill, the relevant page is 36 in the authorities bundle. The one attached to the Act is page 40. When looking at the bill ones for what it's worth, everything is 1 paragraph out. So what's said to be paragraph 30 in the bill is what became paragraph 31.
Is there material difference?
I don't think there is. We say there's nothing, frankly, in either of the explanatory notes which tells you one way or the other, with clarity, whether Parliament intended 2 notices to be served. But we say, if anything, when looking at paragraph 292 in the bill and 427 in the Act, they suggest that 1 notice only was required. My lady, my lords, I'll move on now to the code itself, and that's in the authorities bundle. I'm afraid I will have to go back to that. The first provision I'd like to draw attention to, again, is paragraph 100. We say my own friend failed to give sufficient weight to paragraph 100. This is the provision which prevents contracting out of the code, and it does prevent contracting out. Again, that's what Parliament decided. You cannot contract out of the code. Unlike the 54 Act, if you are an operator and you are getting code type rights, inevitably you are going to be creating a code agreement, assuming you've done it in writing, I should say, and complies with relevant requirements. The reason I draw this to the court's attention is that what this says is that Part 5 does affect rights or liabilities affecting under agreements. So it's an express direction in the code that Part 5 is superseding contractual provisions. And we say that's not a terribly promising start for my learned friend's submission, that actually all the contractual provisions just sort of remain in force and get written over. And going back to, again, that DCMS report that we looked at earlier, page 272 in the bundle of authorities, in the back of the bundle of authorities, this section, we can see the reason for the policy behind this particular provision.
Attention please. This is the Security Control Office. You are now invited to observe a 2-minute silence to mark the 80th anniversary of VE Day. Thank you.
Ms. Tozer, you were at page 273, I think.
272, I hope, my lady.
272 of the authorities bundle.
Yes.
And that is...
It's part of this same DCMS report that I showed at the court earlier. Unfortunately, it was split between two places. And this, in the blue box, this is the explaining the policy behind this Anti-Contracting Act, paragraph 100. And midway down the bottom paragraph, I just highlight this. Given this on balance, the government considers that any attempts by one or more parties to gain advantage by circumventing the new code's provisions must be prohibited if the code is to be truly effective. Will therefore make provision to prohibit contracting out. So I say again, it's quite clear that they weren't interested in preserving contractual bargains at all costs. In fact, they were quite clear that what they wanted was the code to be the predominant governance of the relationships between the parties. And indeed, as I said, my learned friend accepts that the code overwrites some contractual rights, certainly overwrites site providers' contractual rights, because the court may be interested to know that the lease in this particular case contains at page 346 in the supplemental bundle an agreement by the appellants effectively not to rely on any code rights. My learned friend said, oh, well, that doesn't matter because I'm an operator and I can just ignore that. So my learned friend does accept that the effect of the code was to overwrite contractual bargains, but what he invites you to do is say that's a very one-sided thing.
But we do have to bear in mind, though, I think Mr. Lees clarified this morning, that the provisions we've got to grapple with, paragraphs 30 and 31, apply not just to consensual arrangements between two parties negotiating at arm's length, but imposed situations.
Yes.
So you could imagine a situation where an operator proposes terms, it goes through a tribunal process, and the terms which are imposed are break clauses, not unlike the ones we have in this case.
Well, the future practice may depend somewhat on the outcome of the decision.
Well, that's a different point.
I'm not in a position myself to say whether break clauses are habitually included
Be that as it
by
may.
the tribunal, which do not
But be that
marry
as
the
it,
statutory.
be that as it may, the provision's there in the statute. But if we're looking at what can be done under paragraph 31, it may impinge not just on a consensual arrangement, it may impinge on an imposed arrangement,
Yes.
which happens to be expressed through the form of an agreement.
Yes, absolutely. And I don't think that's a point against me. I don't.
But it may mean that things are a little bit more neutral.
Well-
from both sides' perspective.
Well,
I mean, if the tribunal goes to the length of putting in a break clause, or if that has survived a process before the tribunal, then there is this issue about the extent to which paragraph 31 then supplants
Yes.
that arrangement.
yes.
Whether it be consensual or imposed. That's the simple point.
Yeah, it's not our case that it supplants it entirely.
No, that's really what we need to understand.
Yes. Well,
And I'm not
And
sure
how
how
on
much
that-
of this generalised purposive material is going to assist on that.
well, I'm moving on now to look at the wording of the specific sections. But if it helps to say at this stage, in terms of a contractual notice, I can't see the benefit to that. I mean, I'll come back to this in more detail. If your lordship is concerned about the tribunal having said you've got a break in certain like a redevelopment break, for example, I mean, that would be the most likely thing. We say, my learned friend has mischaracterised our case here. We say because of the requirement to show that you could have terminated on the date stated, at the date you serve your paragraph 31 notice, you must be able to show that you would have been able to satisfy those conditions by the date on which you would have needed to satisfy them contractually. That's a bit complicated.
Sorry, can you just say it again?
Because
Let me take my pen.
I think I understand that.
because you've got to serve
You
your
just said
paragraph 31 notice 18 months before, but you might only have to give your contractual notice 6 or 12 months before, or some other period of time.
Would you mind just restating?
We just have the
What you
proposition.
just said.
All right, I'll try. You have to satisfy, if you have a redevelopment break clause, because of the requirement to show that you could have terminated it on the date the paragraph 31 notice expires, you have to be able to show at the date you serve your paragraph 31 notice that you would have been able to satisfy those conditions by the date that you would have had to satisfy them in order to exercise the contractual break for the date stated.
So you're going
In
too
your-
fast for me, I'm sorry.
I'm so sorry.
That's to show on the date that you serve the notice that
That you
Would have been able
that you
to
would have been able to satisfy the conditions
at the expiry of the period.
on the date when contractually you would have had to satisfy those conditions in order to bring the agreement to an end on the date stated in the paragraph 31 notice. And I'm sorry that's complicated, but it's because of the time difference. It's because you have to serve your paragraph 31 notice 18 months before the expiry date, but you might have a contractual right to break on, say, 6 months' notice, and you might have to show an intention to redevelop when you serve that 6 months' notice, or you might have to show it at the end when the notice expires
Depending on the wording of the
of the contract. And so all you've got to show in short for paragraph 31 is that you would have been able contractually to bring it to an end on the date you've stated. But where you've got these conditions, of course, that complicates things a bit, because you've got to think about what you would have to have done under the contract and when you would have to have done it.
I think your hypothetical farmer is scratching his head at this
Well,
stage.
I was going to say, clarity for the farmer with a single field. Absolutely bell crystal.
Well, perhaps it is easier in a normal case. You know, if you say to the the alternative is what you're saying to the farmer is although this contract says to you here that you would only have to give 6 months' notice and you have to make out your redevelopment break then, what you've actually got to do is give, as well as what the statutory notice says, you've got to do something completely different that isn't written down in either the statute or the contract.
We understand your point, Miss Taser.
There it is. So if that's helpful by way of introduction to what's coming later in terms of what the could have regime works, can I just...
Are you going to go to that next?
I'm going to briefly look at paragraph 30 because my learned friend made a link between paragraph 30 and 31.
So we're at paragraph 30.
Before I do that, can I just trespass on the court's goodwill for one more moment? What my learned friend said is about this one-sidedness. He said it just, the code wasn't intended to overwrite any operator rights. You know, that's not what it was about. It wasn't about taking rights away from operators. We assume none of that happened. But that isn't true. Because before the new code came into force, operators had 54 Act-protected tenancies if they had a lease. And under that regime, they would have been entitled to statutory compensation if it was terminated, for example, on a redevelopment ground. And that right is taken away by the code.
But that's not a contractual right, that's a statutory.
No, but I think my learned friend's submission was because the purpose of the code is to confer rights on operators, it can't possibly have been intended that any of this...
But they'd ever be worse off, and you say they were.
That's
okay.
Yeah. All right, so paragraph 30, if we look at that in the bundle, we say there are two parts to it. Two parts to B1, and there was a discussion yesterday about what the word may in 31B Roman 2 means, and we say may means what one would expect it to mean, i.e. has the ability to. It may doesn't mean does, which is what my learned friend says.
Does what?
Well, what my learned friend says is does bring the code agreement to an end. He says you substitute may for does in 30B Roman 2. And I say no. By
the service of a notice?
Yeah, you do.
Is that what the submission is directed at?
Yes, that's what I understand my learned friend's case to be. That when your lordship asked him what may was, he said, well, it means you have actually done it. It means you do. Whereas we say may means may. And it is true, of course, that one doesn't strictly need a continuation unless there has been a termination. But we say the purpose of this provision here was just to reinforce that, frankly, there's no purpose in going through the hoops of bringing about a forfeiture or a contractual termination or anything else, because it will be ineffective. So it's stressing, and I think the forfeiture is perhaps a good example here. What it's effectively saying is, we don't want you going about forfeiting or re-entering because it's going to be ineffective. And the reason why that was important to stress is because, of course, the public interest is in the continuation of service. And so this, I think, explains the background to why forfeiture was perhaps not excluded. And this is simply my own supposition. I don't get this from any prior report. But one thing that was very important was continuation of service. And so you couldn't have site providers going in and purporting to forfeit because that would potentially affect service. And so that's we say a reason why that is there is simply to stress the two parts. That's to say, it could be that you've got a right to bring it to an end, and it could be that you've actually brought it to an end. If you've actually brought it to an end, if you actually served your notice, then you're in B1, because under the terms of the agreement, it would have come to an end. It would have ceased to have been exercisable if you've actually served your notice, and it's expired, I suppose. But B2 is to deal with that, the opposite to that, the situation where you haven't done it, but you could have done it. The other thing that we get from paragraph 13, it's important just to say this, is it's very clear that the contractual scheme itself was not to be effective. So it's not, paragraph 31 isn't giving site providers an additional right to terminate, which is sitting there in parallel with the rights they already had. It's quite clear that paragraph 30 is saying your contractual rights to terminate are gone, and instead you're getting this statutory scheme.
But does that mean that you say, if you've got a break clause, from the moment the break clause is capable of being exercised, it becomes a statutory agreement?
I don't,
because all you need,
think
you
it
say,
matters.
is, and these are alternatives, B2, you have a right to bring the code agreement to an end.
Yes.
And you say if that applies, then it's 32, which not the contract, which confers the
Continuing right.
continuing right.
Well, that would be entirely in accordance with how we say the scheme works.
Well, that is your, I think your
Yes, because
the consequence of what you say may means there.
But because at paragraph 33, of course, once you get to that date, then either party can renegotiate terms effectively, or can ask the tribunal for different terms. So,
But before you get to that date, it's now a statutory paragraph 30, subparagraph 2 agreement. It's not a contractual agreement at all.
oh, I see. Well, I don't think I'd go that far. Although, as I say, I don't think it matters because I think what as I read it anyway, B2 is saying once you get to the position where under the terms of the agreement you can bring it to an end. I don't think it's saying if there's any break right at all ever from the outset, you're within this territory.
Yeah,
but I don't think it matters.
Subparagraph 1 defines when subparagraph 2 applies. Subparagraph 2 applies if A and B. So subparagraph 1 is identifying when subparagraph 2 applies. Is that right?
Yes, yes.
Subparagraph 2, if it applies, come back to that, is essentially there are the statutory rights. Yes, so far so good?
Well,
The agreement continues.
yes.
One of the circumstances which triggers that is paragraph 31B2, site provider may bring the code agreement to an end.
Yes.
You say that doesn't cover circumstances where it has been brought to an end. It's simply whether there's an entitlement, e.g. there is a break clause.
Well, I say when the break date has arisen, when the right to serve the notice has arisen.
Yes. So if it's a 6-month notice, then there's a right to give a 6-month break notice, and you say at that point whether or not it's given.
Yes.
It ceases to be a contractual agreement, and it becomes a statutory agreement.
Yes, I'm not sure that distinction matters because it doesn't. The nature of it because this isn't necessarily a tenancy. It's just this is a code which is dealing with agreements. So I don't think it matters whether it's within this continuation or not. Say for the debate that we're having now about in what circumstances you can seek your
the point is, it strikes me as a slightly odd piece of legislative drafting to say if the parties have got an agreement and they're happily abiding by it and it happens to have a termination right but nobody exercises it, then we must make clear that the agreement rights still continue. That would be completely superfluous, wouldn't it?
Well, as I say, I think the purpose of that was this is the section which is dealing with continuation. And I think the purpose of it was really just to stress and reinforce that you couldn't contractually terminate, so that any of those things you tried to do would be ineffective. So there's no point in even trying. That's as I see it. I'll come on to paragraph 33 in a minute, but I want to finish on paragraph 30 first, if I may, and maybe I can pick up some of your Lordship's question at that point. So the second thing about paragraph 30 to note is that nothing here says, in either paragraph 30 or paragraph 31, that paragraph 31 only operates once the agreement is continuing by virtue of paragraph 30. That was my learned friend's submission. He said, effectively, you infer that relationship between these two provisions. And I say that is not the correct inference to draw. There's nothing express, and there are lots of reasons why that's the wrong inference to draw. The first is that there is no reason for Parliament to have required the parties to serve a notice which they have said is going to be futile, because they've said it will have no effect. So there's no reason why Parliament should have expected parties to do that. Secondly, we say the position is a fortiori if you think about forfeiture, because, of course, in order to bring about a forfeiture, you haven't just got to serve a notice. You've either got to re-enter, and we've already talked about why that would be a bad idea, and Parliament wouldn't have intended people to be doing that, or you've got to issue proceedings. We say it's really unlikely that what Parliament had in mind, and didn't say here, so anyone would know that that's what they're supposed to do, is that what you're supposed to do is issue forfeiture proceedings, which everyone knew would be pointless because of paragraph 30, but you would have to do that as a precursor to serving your paragraph 31 notice. That's my own friend's case.
So it wouldn't be pointless if you take the Shiloh, Spinners and Harding approach of allowing for forfeiture in order to secure compliance with an ongoing agreement.
Well, okay, can I deal with that? So forfeiture only works as the stick, if you like, to beat people into compliance, if the forfeiture is actually possible. So it's not much of a stick here if the answer is, well, I know I can take you to court, but I know my proceedings are going to get struck out because of paragraph 30, because it's going to be ineffective. And the only way that I can terminate is actually by serving a paragraph 31 notice. But I've got to go through that hoop anyway, and then I've got to serve an 18-month notice. That's not much of a stick. So that's why I say...
Because there's going to be continuation anyway.
Yeah. Yeah. So the proceedings are going to kind of go nowhere.
Which is why Parliament had a specific provision
in the 54 Act, no doubt. Yes. And I suppose policy-wise, it wanted landlords to be able to remove defaulting tenants quickly without going through the statutory regime, whereas here, because the policy is network connectivity at all costs, or so it's said, we don't do that. So the point I'm trying to make here is that my learned friend's construction of the relationship between paragraph 30 and 31 is that in a forfeiture case, what one would have to do is actually issue these proceedings, which everyone knew were rubbish, just to effect the forfeiture, in order then to give the right to serve the paragraph 31 notice. And 18 months would go past, and so on and so on. So we say, again, why would Parliament have intended something so absurd as that? Site providers would be incurring costs, the court system would be getting clogged up. There's just no basis to assume, without anything in the wording to tell us that that's what was required, that is what is required. And we say there's nothing incoherent in a scheme that says, right, you operators are getting all these protections. We've taken away forfeiture, we've given you this long 18-month notice period, you're getting all these protections, but in return for that, what the site provider is getting is a right to terminate in these statutory situations. You know, he's got to give his 18 months notice, and he's got to make out one of these statutory grounds. And we say there is nothing absurd in Parliament having reached the view that that is the fair balance, regardless of what the parties might have thought, because it's quite clear that they do overwrite parties' bargains. We say that's a perfectly sensible way to construe the statute.
Effectively, forfeiture is replaced by ground A.
A and B.
A and B.
A and B.
Yeah.
but with an 18-month lead period and in my learned friend's case, another process beforehand.
And the ought to wording may be sufficient to encompass relief from forfeiture considerations.
Yes, well, that's the difference between A and B and C and D. So at 32.4, the court will see that the tribunal, if once the grounds are established and the tribunal's got no choice, it must order the agreement to come to an end. But of course, before that stage in A and B, it's got to consider whether it ought to come to an end. So again, there's that element of how serious, I suppose, how serious is it that this rent hasn't been paid or whatever it is.
And whether it's continued. And if when you get to that stage,
presumably,
there's been full compliance since.
We say there's nothing incoherent in this being a freestanding statutory scheme. Going on now to the wording of paragraph 31.3b, we say this really makes it clear. 3b, this is the provision about the timing in the notice. And as I say, we say that the first half of 31, so 31A is just dealing with the straight 18 months, and B is where we get back into what the contract would otherwise have provided by way of termination date. And the first half of A deals with two situations. Firstly, where it would have come to an end by a fluxion of time, but also the situation where a break notice has been served. Because if a break notice has been served, then the agreement would, but for paragraph 30, come to an end, or the rights would cease to be exercisable by the site provider. And
sorry, can you just say that again?
yes, so the first half, so the part of the phrase before the or on the third line,
Yeah.
so after the date at which the code right would have ceased to be exercisable or by the site provider, that bit is where we say you fall if you have in fact served a break notice. Because if you have in fact served a break notice, then if paragraph 30 didn't exist, the code right would have ceased to be exercisable. And so that then leaves the question, what is the second part of the clause doing? And we say the answer to that is really obvious, because we say it's precisely to deal with the situation where you haven't bothered to serve a break notice because you know it would be futile because you've read paragraph 30, but it could have been. And we say what this second part of the clause is doing is dealing with that situation, and it's telling you that you can terminate at a time when you could have brought it to an end. And we say this discrepancy or distinction between the could in the second part of the clause and the would in the first part of the clause is absolutely not accidental. That it's absolutely deliberate and intended to show that in the first half, the things have happened that need to have happened, and in the second half, it's a hypothetical, if you like. It's what could have happened. And similarly, we say there's a reason why there's a distinction between after in the first half of the clause and at in the second half of the clause. Because we say if you have served a break notice, and this, my learned friend dealt with an example yesterday, if you've got one of those clauses which is you must serve your break clause no less than 6 but no more than 12 months before the break date. Just in passing, I think my learned friend suggested I'd contrived that somehow. I am told on instruction that that is a clause which does appear in telecoms leases. If you've got something like that, then you would need to be in B, because you couldn't serve a para 31 notice for that for the same date, because you couldn't serve your para 31 notice and your contractual notice at the same time because of the 18-month requirement. But what you could do is serve your contractual notice, and then you get yourself in the first half of the clause, and then you can serve a para 31 notice to expire at any time. It doesn't matter that it's not expiring on the same date as the date stated in your notice, because you've actually served your notice. So that's the answer, I think, to the conundrum. But it explains the difference in wording between the after and the at, which, again, we say must have been significant. It must have been intended to do something.
It's my fault. I haven't quite followed that. Could you just
I'm so
work
sorry.
that through with an example?
All right. So let's suppose you've got a contractual break that says no less than no more than 12 months' notice can be served,
Yeah.
and you want to exercise that. You can't, we say, do that. Well, if you serve, what you can't do is serve a contractual notice for 18 months because that doesn't fit with the contractual clause.
Says not.
So it doesn't work. So you can't do that. So what you can't do is serve what my learned friend calls a double duty notice, i.e. a para 31 notice with a covering letter that says we're exercising our contractual break and here it all is. You can't do that. And what you can't do also is serve a separate contractual notice to expire on the same date as your para 18 notice, para 31 notice with your 18 months. You can't do that because that would be giving too much notice. You could do it later, but that wouldn't be any good for either part of the clause. So on the
You
date,
could do it later because then you wouldn't have satisfied your 31 requirements.
when you gave your
18-month
para
mark.
31 notice, you wouldn't be giving it. You wouldn't satisfy the second half because you wouldn't be giving it at a time when it could have been brought to an end. So, sorry, I'm not right about that. I'm so sorry. So the first half is if you've already given your statutory notice, your contractual notice for your date. Let's say you've given a 6-month notice. At any point after that, you can give your paragraph 31 notice. And it doesn't matter that the date in your paragraph 31 notice is going to be later than your contractual date, because the first part of paragraph B says after the time at which, for paragraph 30, the code right would have ceased to be exercisable or by the site provider. So that's okay. That scenario is okay. If you contractual notice first and then para 31 expiring on a different date, it's after the date that you've brought it to an end, that's okay in the first half.
I'm sorry, my fault. What you're envisaging is you've got a not less than 6 and not more than 12 months.
Yeah.
And you want to give your contractual notice now for...
Let's say you want to terminate as quickly as you can. Let's just suppose that.
You can give contractual notice now, and you can give your statutory notice, but the statutory notice has to have a date
After.
18
Yeah.
months away, because that's what subparagraph A requires.
Yes.
Why are we concerned with any of subparagraph B in those circumstances? Subparagraph B isn't it? Only if it's going to give rise to more than 18 months.
No, I don't think so, my lord. I think there are two separate requirements to meet. So in many cases, contractually, it would be less than 18 months. The 18 months is almost extending the provision. But B is also saying there's another thing that you've got to satisfy when you're specifying your date. One is that it's got to be 18 months, but the other is it's got to be either after the time when it would have come to an end contractually, or at a time when it could have come to an end contractually. So you've got to make your statutory notice expire either after the time when it would have expired by a fluxion of time, or the break notice which you've actually served would have expired, or you've got the date you specify in your para 31 notice has got to be at a time when you could have brought it to an end. Now, what my learned friend says about the second part of that is...
Before you do that,
yes.
Can you go back to your example? Therefore,
Yes.
we've got a break clause no more than 12 months.
Yep.
So you're saying then that you serve that,
Yes.
and then you can serve your 31.
Yes.
And the 18 months will obviously be longer.
And whenever it ends, but that's okay.
But it's satisfying A and B because it's after the time.
And the first part of B, because it's after the time. Yeah. So the second part of B is dealing with the situation where you haven't served your contractual break, And what my learned friend says, I think, in relation to that, is if you serve, that because you've got to serve your contractual notice beforehand, before you can give your para 31, well, I'm not sure exactly what it is. What we say is you don't have to serve your contractual notice beforehand, so it's not a trap. You could give your paragraph 18 notice for the date, whenever it is, and then serve, and because you would be able after that date to serve a contractual notice for the same expiry date. Whereas I think what my learned friend says is that gives rise to a slightly more complicated situation, and that's why he says you don't read at as meaning at, you read at as meaning after, even though there's a clear discrepancy between these two parts of the clause.
It's my fault. I'm not quite following. So, I understand you say if you do give your 12-month notice, that fulfils the first part, because it'll only be 12 months after which the right would have ceased to exist. But if you don't give your notice,
yes,
so that you're having to rely on the second part of
yes,
B, you can't do it.
Well, that's what my learned friend says, I think. Although
I thought that's what you were saying, because that means at, not after.
Well, but what we say is all you've got to show on the date when you serve your paragraph 31 notice is that you, on the balance of probabilities, looking at things on that date you serve it, that you would be able to serve a contractual notice in due time, comply with all the contractual conditions. This is the complicated bit I said earlier. At the time you would have to under the contract in order to bring it to an end on the date that you've stated.
Well, I understand that's what you're saying. I don't understand how you get that out of the distinction between after and at. Because if you have to rely on the second part of B,
yes,
you're looking at the hypothetical. You haven't actually exercised your break clause, and
yes,
in our not less than 6, not more than 12 months, you can't then give a notice that complies with paragraph 31, because you can't give a notice that contractually that takes effect at the end of the period.
On my learned friend's case, no, because what my learned friend says is you've got to be able to give your contractual notice at the same time. And I'm saying, well, that isn't right. You haven't got to be able to give your contractual notice at the same time, or before, I think he says. I'm saying that isn't the case, because all you've got to be able to show is that by the expiry date,
in 6 months' time,
you could do it.
You could do it.
Yeah. That's the nub of the distinction between us, I think, in relation to conditions. I'm conscious of the time. I'll move on, if I may, to paragraph 33. Paragraph 33. My learned friend took your lordships and your ladyship to this yesterday. It's the one that says effectively once the site provider can break, then either party can go and seek fresh terms from the tribunal. Doesn't mean the tribunal's going to give it to them, but the parties can ask. And again, what my learned friend says about this is you've got to assume before the site provider might know very well he's got no statutory grounds to terminate at all. But what my learned friend says is, well, the site provider has still got to serve a break notice, even though he doesn't actually want to break and he accepts that he can't break because he's got no statutory grounds, just to get through the gateway, through the anterior gateway, in order to be able to go and say to the tribunal, oh, actually, what I'm really trying to do is modify some terms. So we say that's, again, unlikely that Parliament would have intended to add that pointless layer of complexity to what the parties were trying to do.
Sorry, I want to take a note of this.
Okay, I'm so sorry.
So we're looking at 33,
yes.
Subparagraph.
33 is the provision
yes.
which says that either party can ask the court to modify the terms.
Yes, I appreciate that.
And 33(3)(b) is in the same terms as 31(3)(b).
That was the bit I was looking for. Thank you.
And so what my learned friend says is it works the same, that in order to get within paragraph 33, he accepts that the logic is you've got to do all these same things before the jurisdiction in paragraph 33 is triggered. So you've still got to forfeit.
So let's say we've got a situation before an agreement comes to an end by a fluxion of time, but there's a break notice clause. That's why we're looking at this.
Yes.
So how, on your case, would this apply to the break notice clause, either a simple one or a conditional one?
Well, again, we say it's the same.
Yes,
we simply have to show that by the date that's given in this notice, you must have been able to contractually bring it to an end. You've got to demonstrate on the balance of probabilities that by the expiry date, you would have been able to, the site provider would have been able to bring it to an end contractually. So it's the same test. The difference is simply whether you assume that you've actually got to go through those hoops rather than just showing that you could have done it. And my learned friend's case is you've got to go through all those hoops. You've got to go through the hoop of showing, for example, that there's a forfeiture and you've issued your proceedings, or that there's you've actually paid £1 million that wouldn't have to be paid till vacant possession was given, or whatever it is. You've got to do all those things before you can even ask the tribunal to modify the terms. Even if we all accept, we all know that there's no ground for termination, termination's not on the cards. You've still got to comply with all of that regime. So that's my learned friend's case. And we say it's even the fact that it only applies where there's a site provider break, so that the operator has this right to seek for the terms to be modified when the site provider has a break right. We say that makes it all the more unlikely that it was intended that there was a gateway, that these things had actually happened, because otherwise that makes the operator's right to seek modification of the terms entirely within the site provider's hands. And we say that's not warranted.
And what happens about part of the break is that you have to pay £100,000. Mr. Lees's example, you say it's sufficient because of the could we're in 33.3b in the second limb, that you have to show that you could have done, you were in a position to, you had the money at hand, or you could have borrowed it, etc. But you don't say that you have to do it. Does that happen if the tribunal makes the terms that you then would have to do it? Where does the £100,000 go?
I was proposing to deal with conditions is quite a long passage. I was proposing to deal with that after lunch, but I'll briefly answer your ladyship's question now. So we say it's clear from the statute that you don't need to pay your 100,000 either in order to get your paragraph 31 to be valid, or in order for your termination to be effective. However, we say that a paragraph, that all that has happened, and I've come to an authority at least on this after lunch, all that has been overwritten is the termination regime. There's nothing to say that there may not be a separate contractual obligation. And by way of sort of trailer to what's coming, what we say is, if, for example, the contract had said, if I exercise my statutory right to terminate, then I will pay you £1 million. There's no reason for that sort of provision to be overwritten. The £1 million would be recoverable as a matter of contract. And so where you've got conditions that say things like, if I'll pay you £1 million when you give vacant possession, and there is that baked into that is a difficulty that's baked into my learned friends' examples, because in a lot of cases the contractual provision, I mean, not that there are ever these premiums for paying £1 million, but on vacant possession is something which the operator is never in fact giving in any of these examples. In my learned friend's example, the £1 million has to be paid at a time when contractually it's not even due in order to be able to serve a valid notice. That's my learned friend's case. So that's another problem. But on our case, we say it's a question of construction of the contract, whether there is implicit in an ineffective contractual condition, because that contractual scheme's been overwritten, a contractual promise to pay, which would remain enforceable after
So effective but ineffective, but if effective.
It's not required in order for the termination to be effective. And that's the point, or indeed the notice to be valid, which is actually the point that we're discussing here. But it could still have a separate contractual life in terms of a damages requirement. And after lunch, I'll take the court to Fell in relation to that, and we can look at that as an example. Just going back to paragraph 33, if I may, I want to deal with my learned friend's submission about operators hijacking the site provider's break, I think is what he said. He was concerned about that. And my answer to that is, well, why not? Why not suppose that Parliament intended operators to be able to do this in cases where site providers chose to seek a break against this statutory regime? My learned friend's case about the policy of the code is all about giving lots of new rights to operators and all about making life easy for operators and making sure that they've got all the rights they need. So it's perfectly consistent with what my learned friend says the policy of the code is, to suggest that operators would be able to have a crack at persuading the tribunal. I mean, they might not get it. The tribunal might say, well, look, this is a mid-term situation. The site provider's not exercising the break. I'm not going to give you any modification of the terms. But it's, as I say, it's entirely consistent with the policy of the code to say that the operators should be able to do that. And we say on our construction of the policy of the code, the fair balance, it's also entirely consistent with that, because the site provider never has to take a break. The site provider could say, well, look, I want to be sure that the operator is going to be held to this for the full 10-year period. Fine, then the site provider doesn't take a break and there's no opportunity for either party to renegotiate the terms. But if the site provider does want a break, there's no reason to say that Parliament didn't intend there to be a kind of quid pro quo for operators in those circumstances, which is, well,
It's my fault, but 33 can be triggered by an operator, irrespective of whether the site provider has sought to terminate under 31, yes?
Yes.
And I thought that Mr. Lee's point was that if the site provider hasn't, but would have a right to,
yes,
not exercised right, then that gets the operator within 33(3)(b), because it's the code agreement could have been brought to an end by the site provider, if you're right.
That's our case, yes.
And it hasn't happened. So
yes, and I
you
think
say that there's no injustice to the site provider in the operator being given in those circumstances an opportunity to renegotiate the terms which he doesn't have contractually.
Yes, and for two reasons, my lord. The first is that the site provider doesn't have to take a break. If the site provider chooses to insert a break clause in those circumstances, then they take the consequences. If they don't want the operator to have a mid-term opportunity to renegotiate terms, then they simply...
So when you say if the site provider doesn't want a break, you mean if the site provider doesn't contract for
exactly. I'm sorry. Yes, at the point at the
rather
beginning.
Rather than exercise a break.
Yes, doesn't want exactly.
I see.
Exactly. So they don't have
so
to include
that's a risk he takes.
Yes, exactly. If that's that's the quid pro quo for having that future right available to him, what's in return for that is...
This may explain, because I didn't understand earlier on when you submitted, if the provider wants a break, then there's no reason why, as a matter of policy, the site operator shouldn't be able to exercise, rely on 33(3).
Yes.
But the language needs to be precise. It depends what you mean by want a break.
Yes, I'm so sorry.
What you mean is
want a break clause.
If there's a break clause.
Yes, I'm so sorry.
A contractual option.
I'm so sorry. Yes, that's how I should have phrased it.
As opposed to
actually wanting a break.
exercised.
Which is where I was.
I'm so sorry. I've confused everybody. I'm sorry.
But the hijack point is a good point then, isn't it? Because you say the consequence is that merely because the clause exists, because the provider wanted it in the contract, there is the opportunity to use 33.3.
Well,
the break clause doesn't have to be exercised.
You say that is the effect, but it's not right to describe it as a hijack.
Because
it's a perfectly sensible balancing of rights.
Exactly, between
the operator
parties.
gets better.
Because
a better deal in this respect than he contractually bargained for. But that's consistent with that's the quid pro quo.
For other things,
for the landlord having insisted upon having an option
to break.
At what point on this analysis can the operator rely upon 33.3? It's merely because of the existence of the clause in the agreement, isn't it?
When the landlord's break
date
arises, then the operator can take advantage of it.
Yes.
That's more neutrally than
are you postulating a simple break clause which says when you reach 5 years into a 10-year term you can exercise a break clause? What about a conditional break clause?
Well, granted, that's likely to be much more difficult for the operator to demonstrate that it would have been possible for the site provider to break at that date.
If he didn't want to.
Yeah, well, I don't think it's about if he didn't want to, but I mean, if it were conditional, for example, on redevelopment, and the site provider just had no plans to redevelop, then the operator wouldn't be able to show that it would have. It was after a date when it could have been brought to know by the site provider, because the site provider wasn't through the gateway.
You said there's no hijack in a situation where there's a simple break clause. There's the ability to break at a certain date, whether or not it's exercised. There's no reasons matter policy why 33.3 couldn't be operated by the site operator. Is that where the submission gets to?
But yes, I think it's two things. I think it's firstly that of course there's no obligation on the site provider to take a break. They could just contract for. They obviously want, let's say, a 10-year term. They want to give themselves the option to break early at 5 years, let's say. They don't have to do that. If they don't want the operator to have the ability to go and potentially renegotiate terms, they should just take a straight 10 years. But they've got the benefit of an early break, and Parliament has decided, we say, that the consequence of that is that at that stage, either party can go to the tribunal and say, okay, well, look, how's about the terms? And the tribunal might say no, as I said. They might say, no, that we're not prepared to do that. But it gives the parties an opportunity to ask.
Again, I think the hypothetical farmer might be rather surprised simply by giving himself an option. He's exposed himself to the whole thing being renegotiated after 5 years.
Well, at least the hypothetical farmer can read it in the code. The difference is, I think, that on my learned friend's case, the hypothetical farmer is surprised by things which are nowhere written down. And that's what we say is unfair.
And it's absolutely clear.
I'm glad. Very quickly, if I may, I wanted to say something about the 54 Act before lunch. I'm conscious that your lordships and your ladyship may have read some of the authorities in relation to that. It'd be helpful, perhaps if I can get an indication before we break for lunch, as to how widely that reading has gone. Before we come to the authorities themselves, there is a passage in the Law Commission reports that I wanted to show your lordships and ladyship. It's in the bundle at page 294. There's actually quite a lot.
294 in
supplemental bundle. I'm so sorry.
Thank you.
There are quite a lot of passages which make it clear that the 54 Act was used as the model for the code security regime in general. But paragraph 6.105 makes it clear that the notice regime that was proposed in the code was to be analogous to a notice under section 25 of the 54 Act.
It doesn't help very much, though, because the real question is how close is it as an analogy or how distant?
Well,
and for that we need to go to the code itself.
Yes, my lord, yes. But I simply want to make the point that if there's any doubt about why we're looking at the 1954 Act authorities, it's because we say...
Well, we understand that.
I'm grateful.
Before we do this, would you mind, I've been waiting to ask a question. I want to understand the difference between the parties on the use of the word may or could.
Yes.
Yesterday I wrote down when Mr. Lees was making submissions, we looked at the word may. He says it indicates there is a right to break and it is exercised.
Yes.
You say that it doesn't have to be exercised,
Yes.
but there must be more than the mere existence of a term in the agreement. There must be the circumstances which entitle it to be exercised. Is that an accurate way of putting it?
My lord, yes,
Shortly?
I'm sure that's much better than the way I've put it so far.
Circs entitling. And then you helpfully went on to explain the temporal aspect.
The date's a bit
Yeah.
difficult, my lord, yes.
So sorry, beg your pardon. No, please.
Go, no, please go on.
So that's why you wouldn't accept that the only aspect which is imported from a contract into this termination provision is simply timing as such.
Yes, it's more complicated.
Well, perhaps try and avoid making things complicated. It's certainly timing, but linked to the basis upon which you could break.
Yes.
And showing that the circumstances triggering that would be satisfied.
If the break were conditional. Of course, it's
yes.
just timing if you've got a straightforward break.
Yes.
And so I'm not entirely aligned with my learned friend as to what's common in these type agreements. And perhaps mentioned that briefly this afternoon as well. But in a simple case, which may, for all we know, have been what Parliament was envisaging, it is just a question of timing.
So the difference between the two of you is exercise, and in this context, exercise by the service of a contractual notice.
Well, I think, as I said, I think there's three things. I think my learned friend says you need a notice. The Upper Tribunal said, well, you don't need a notice, but you do need to state your grounds. And then my learned friend says, well, let's think about conditions as well.
Well, forgive me, these are your 3 points much earlier on. But your third point was, even if you don't need to specify the grounds, you nonetheless have to have them.
Yes.
That would rather suggest it'd be a good idea to specify them so everyone knows what you're talking about.
Well, we are getting somewhat ahead, my lord, but that was the view.
Seems to be rather central. But in the event, you have to have the grounds. There have to be the circumstances which would enable the break clause to be relied upon.
Yeah. Can I just, in answer, there are a number of points I want to make in answer to your lordship's point, but the first one is, of course, the temporal point. That under the contract, if you've only got to give 6 months' notice, you've only got to state your contractual grounds 6 months before the relevant expiry date, the effect of the Upper Tribunal's decision that grounds have to be stated at the date when the paragraph 31 notice is given is to require the site provider to decide a full year earlier than he otherwise would have to what contractual ground he's going to rely on and make out. That may or may not be possible. If it is a case, I mean, it may not be a case where there's more than one ground anyway, but if it is a case where there's more than one ground, then if the site provider simply doesn't know what contractual ground he's going to be relying on a year down the line, he might just state all of them, which makes it a bit of a pointless exercise.
I mean, one of the problems, it seems to me, at least listening to the argument, is that each side has a different perspective as to what the other side is saying. So Mr. Lees was saying yesterday, you're only importing timing. You're saying, no, that's not right. I also import the necessity for the circumstances to exist.
That you could have. That's what we said below as well. So.
Yeah, well, no doubt. But now we see the differences are narrower than was being described yesterday. Why does it matter in this case? If this was a preliminary issue, the circumstances haven't yet been determined by the tribunal, why does the preliminary issue actually matter?
What my learned friend says is, because I specified a ground which he says was not open to me, my contractual notice was invalid, and therefore my paragraph 31 notice valid.
Exactly.
Therefore he wants me
The
to
whole
start
argument
again.
is being skewed by the notice point.
Well, the notice point is the argument, my lord.
It's little 5 is the bottom root cause of all of this.
Well, only if your lordships and your ladyship are with my learned friend. If you're with me,
No, but the tangle that you're in is as a result of is it little 5 or is it 2?
But yes.
well,
But even if, say for the sake of argument, you didn't have to serve a notice, but you're right, if I've grasped it correctly, that the circumstances must exist. In a case under this particular agreement's clause 5.8, if you're relying upon ground 5, you have to show that your entitlement does in fact arise under 5.
well, you have to show that you could have terminated under our cases, let's be clear, that at the date we served our paragraph 31 notice, which gave an 18-month period, that we could have brought it to an end contractually by that date in 18 months' time.
Without the precise ground matter?
Well, we'd have to show. In this case, we say it doesn't matter because we say it must be one or the other. So we say everyone would have known because of the way the thing is drafted. Everyone would have known. There was no doubt we'd make out one contractual ground or the other by the expiration date.
Is that right? Given that there are qualifications to 1 to 4.
Well, possibly we did.
It isn't.
I don't think they
It doesn't
disputed,
mean
but
any reason. Here's 1, 2, 3, and 4, and 5 anyway.
Yeah.
So I think it's common ground. If you do come within disposal, you've got to deal with the competitor in the portfolio.
Yes, although
so
I think it's common
say,
ground that one is satisfied. That's why I said, given what was said below. So it's
well,
common.
can I just, before we break, because otherwise I'll forget it, just see if I've understood conceptually that there are at least 3 different concepts. There is a legal right, the existence of a legal right in some circumstances to terminate. There are the factual circumstances, which means that the right is exercisable, and there is the actual exercise of the right. Those are in my mind, the 3 stages, as it were. You don't say, I think, that the first of those is sufficient in the abstract. If you have a legal right to terminate for some reason, you've got also to show, my category 2, that the factual circumstances will arise before the end of the...
By the relevant contractual
date. So you say 1 and 2, but not 3, not actual exercise.
Yes, and I think what my learned friend says is not only 1, 2, and 3, but he also his 2 is different in a sense because he says all of those circumstances have actually got to exist at the date you serve your Power 31 notice. So there's a timing point in 2. So I haven't, in fact, started on the 54 Act Authority, so we'll leave those till after lunch.
Yes, I think that's right, and we'll discuss the extent that it's necessary to go into those, I think, at 2 o'clock.
I'm very grateful.
Thank you.